Welcome to Chapter 13's lecture, and this week we're going to be talking about the courts, which is the judicial branch of government. And I will say we will touch on district courts, but a majority of this is going to touch on the U.S. Supreme Court. So we'll dive in. As always, please watch this video in its entirety after you've read your chapter and take notes. All right, there's a lot of information, and this is probably one of my favorite chapters just because I love studying the courts and just kind of listening to their decision making and things like that, because court decisions have an impact on our daily lives. And so hopefully by the end of this module, you will have learned how that happens. So this quote is by John Marshall, who was the first Chief Justice of the U.S. Supreme Court. And it says, "It is emphatically the province and the duty of the judicial department to say what the law is. As democratic institutions struggle to balance individual freedoms and collective well-being, the judiciary is arguably the branch where the individual has the best chance to be heard. The U.S. courts pride themselves on two achievements. First, as part of the framers' systems of checks and balances, they protect the sanctity of the U.S. Constitution from breaches by other branches of government. There's that checks and balances. And then secondly, they protect individual rights against societal and governmental oppression." Here is an example from your book. The Marriage Equality Act vote in Albany, New York on July 24th, 2011 was just one of the number of cases testing the constitutionality of both federal and state law that ultimately led to the U.S. Supreme Court to take up the controversial issue of same-sex marriage. In the years leading up to the 2015 ruling that same-sex couples have the right to marry in all 50 states, marriage equality had become a key issue in the civil rights debate for the LGBTQ community. And as we all know and have talked about during our civil rights chapter, Obergefell, that decision legalized same-sex marriage and thus allowed this debate to be put to rest for now. Here you see a picture of the front steps of the U.S. Supreme Court. The U.S. Supreme Court building is in Washington, D.C., was not completed until 1935. Engraved on its marble front is the motto, "Equal justice under the law," while its east side says, "Justice, the guardian of liberty." And fun fact, before the Supreme Court had its own building, it actually held its hearings in a chamber of Congress. So that's just a little trivia tidbit for you. All right, so before we can talk about the judicial branch of government, we have to first understand law. Now, this is not going to be an in-depth thing. I'm going to give you a big picture view of everything. So there's two types of law for the sake of this argument and for this chapter. There are two types of law that you should be familiar with. The first is criminal law. Criminal law is law that defines conduct that is prohibited because it harms others. The outcome for these laws being broken is typically a punishment of some sort. Then there is civil law. Civil law spells out the duties that the individuals in our society owe to each other or their government. Typically, in civil cases, a private party sues another private party. And the objective of the civil suit is to make the defendant or the person being sued comply with a legal duty or pay monetary damages. All right, so two types of law, criminal and civil. Civil, you're seeking monetary damages. Criminal, you're seeking punishment for a violation of a law. And it typically is punitive in nature. Here you will see a picture of John Jay, who I just shared the quote with. He was the first Chief Justice of the Supreme Court, but resigned his post to become governor of New York. Then we had John Marshall, who served as Chief Justice for 34 years, and he is often credited as the major force defining the modern court's role in U.S. government. John Marshall, there is a statue of John Marshall in the Supreme Court, and he gets the statue because he essentially created what is the modern court's influence in government. All right. So Article 3 of the U.S. Constitution establishes the courts and defines their role as the third branch of government. When we talk about the courts this week, I will be paying particular attention to the federal judiciary, which hear federal cases and typically has what's known as appellate jurisdiction. Jurisdiction is the term we use for saying the court has the quote-unquote right to hear the case. There are two types of jurisdiction. First is original jurisdiction. This is the first level, and cases are heard for the first time. Think of these as your criminal courts or your superior courts. Next, there is appellate jurisdiction. And how I remember this is appeal. Appellate jurisdictions here and appellate courts hear appeals from the original jurisdiction courts. Appellate jurisdiction means that the current court or the appellate court is not hearing the case, but they're reviewing the records from the lower courts and determining if that court applied the law correctly or if the court violated any due process laws. Appellate courts can override lower courts. The U.S. Supreme Court operates on appellate jurisdiction. So, with your jurisdictions, remember, original jurisdiction, cases are heard for the first time. Those are your typical superior court cases. Appellate jurisdiction is the second level and is typically the court reviewing the records of the lower court, hearing arguments around the lower court's decision, and they have the authority to overturn a lower court's ruling. The power of courts to decide the constitutionality of actions taken by the legislative branch and the executive branch, known as judicial review, is not expressly written in the Constitution. Rather, the Supreme Court claimed that power for themselves in Marbury versus Madison. We'll discuss that case here in just a few minutes, but this is something you want to know. You will need to know this case. Marbury versus Madison changed the game in terms of judicial power and the judiciary's branch of government's power. As we will talk about, this premise of judicial review. And essentially, judicial review says that the U.S. Supreme Court has the right to review other courts' decisions. Okay? In their role as policymakers, Congress and the President consider broad questions of public policy and their cost and benefits. The courts consider specific cases with narrower questions, thus enabling them to focus more closely than other government institutions on the exact context of the individual group or issues affected by the decision. Legislature can make policy through a statute, and the executive branch can do so through regulations and administrations. The judicial branch can influence policy through its rulings and interpretations. As cases are brought to court, court decisions can help shape public policy. So go back to the Obergefell same-sex marriage discussion that we just talked about. It was not federal public policy to recognize same-sex marriage until the court ruled that it was constitutional. Thus, they affected the entire public policy arena by recognizing same-sex marriage. All right, so let's talk about Marbury versus Madison. This is, like I said, take notes, highlight this, do what you have to do, because this is a historic case that we're going to talk about. And I'm going to talk to you, and I'm going to kind of explain everything and why this is the way that it is. So the case originated in early 1801 as part of the political and ideological rivalry between outgoing President John Adams and incoming President Thomas Jefferson. Adams had lost the presidential election of 1800 to Jefferson. In March 1801, just 2 days before his term was supposed to end, he appointed several dozen Federalist Party supporters as new circuit judges and justices of the peace positions in an attempt to frustrate Jefferson and his supporters in the Democratic-Republican Party. The U.S. Senate quickly affirmed Adams' appointments, but outgoing Secretary of State John Marshall did not deliver all of the new judges' commissions before Adams' departure and Jefferson's inauguration. Jefferson believed the undelivered commissions were void and instructed the Secretary of State, James Madison, not to deliver them, which essentially means sign on to them and make them official. One of those undelivered commissions belonged to William Marbury, a Maryland businessman who had been a strong supporter of Adams and the Federalists. In late 1801, after Madison had repeatedly refused to deliver his commission, Marbury filed a lawsuit with the Supreme Court asking the court to issue a writ of mandamus, forcing Madison to deliver his commission. Marbury sued Madison in the Supreme Court to get the commission via a writ of mandamus. So you have this battle between Marbury and Madison where Marbury says, I have a right to this judgeship because the outgoing president signed my commission. However, Madison failed to sign and deliver the commission. Therefore, Marbury couldn't take office like he was supposed to, and now you have an opposing party who won't sign it. So this went all the way to the Supreme Court. Now remember, John Marshall, the guy with the big chair statue, the guy who kind of reshaped the court as we know it, they had, under his ruling, well, not his ruling, under his leadership of the court, I think is best to say. The court specifically held that the provision in the 1789 Act granting the Supreme Court the power to issue a writ of mandamus was unconstitutional. More importantly, however, Marshall's opinion established that the Supreme Court has the authority under the Supremacy Clause and Article 3, subsection 2 of the Constitution to review legislative and executive acts and find them unconstitutional. Ding, 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 ding. This is known as judicial review. John Marshall came up with the concept of judicial review, thus changing the judiciary branch's power forever. The court also delineated the limits of the Supreme Court's original jurisdiction, namely stating that political questions are not reviewable by federal courts. It also described the limitations of the federal court's jurisdiction set forth in Article 3 of the Constitution. While Marbury v. Madison limited federal court's jurisdiction, it cemented the court's status as the ultimate interpreter of the Constitution. Again, judicial review is historic. Under Marshall's opinion and leadership, it changed this branch of government as we know it, and they still are the ultimate arbiters of the Constitution, of interpreting the Constitution today. So in American government and in our current system, we have what's known as a dual court system. And basically a dual court system means that we have courts that run both federal and state level. Okay, and we're going to talk about that a little bit. Here you're going to see a breakdown of federal and state. So on this side, let me get my pointer. So on this side, you're going to see the state judiciary. On this side, you're going to see the federal judiciary. All roads lead to the U.S. Supreme Court, who is the ultimate court and last stop. Okay? The U.S. judiciary features a dual court system comprising a federal court system and the courts in each of the 50 states. On both the federal and state sides, the U.S. Supreme Court is at the top and is the final court of appeal. However, we're going to talk about how the U.S. Supreme Court picks their cases. Not all cases are appropriate to go to the Supreme Court. So if you notice, each state has its own Supreme Court. So typically in states, you have your original jurisdiction courts, which are your trial courts, like your superior courts and things. Then you have your first level appellate courts. And then you have your state Supreme Court. Okay? If it's state laws being broken, they typically are heard on the state side. If there are federal crimes typically get heard in the U.S. district courts. Okay? So not all crimes go straight to district court. So hate crimes, if you think about it, if a prosecutor, you can be prosecuted on a state level for murder, but if the prosecutor tacks on a federal hate crime charge, then you go into the second level and go to a district court and appellate court and then to the Supreme Court ultimately. All right, state courts are set up by the states and are the core of the judicial system. Federal courts handle federal laws and questions of constitutional nature. So that's important. The federal laws typically handle constitutional questions. So here is something that you should probably take heed of. State courts and federal courts. So state courts hear most of your day-to-day cases. In fact, state courts cover 90% of all cases. They hear both civil and criminal matters, and they help states retain their own sovereignty in judicial matters, which means they basically help the states retain their own powers. All right? So there's some pros and cons to having a dual court system. A major pro is that each person has more than just one court ready to protect their rights. A couple of cons with the existence of the dual court system means that there's different courts in which a person could face charges in. A lot of it has to do with jurisdiction. So like what states? Is it interstate? Did it happen across multiple states? Would that be federal jurisdiction? Would that be state jurisdiction? Then there are also some legality questions that make the dual court system really complex. And we've talked about one of these before. We're going to talk about it right now. As you learned in Chapter 3, marijuana laws vary remarkably across the 50 states. In most states, marijuana use is illegal, as it is under federal law. But some states have decriminalized it, which means that, and some allow it for medicinal use, and some have it for both. Currently, marijuana is legal for recreational use in 16 states. However, federally, marijuana is illegal. Therefore, someone can be prosecuted in federal court, federal district court, for violating a federal law where it may be legal in a certain state. So remember back to our discussion during that time, some of the videos you saw, some of the marijuana dispensaries and things like that were worried that they could be subject to federal raid. And then we're going to have a battle that I think would be, I don't know, it would be mind-boggling, because you ultimately would have the power struggle between the federal and state level in that. But let's say you're in Colorado where it's legal, and you come to Georgia where it's not legal, you can face federal charges depending on the amount, or state charges. So that's the complexity between different state laws and federal law that makes the dual court system a little more complex. All right, so let's talk about district and circuit courts. So there are 94 U.S. district courts. These are the trial courts of the national system in which federal cases are tried. No district court crosses state lines, and a single judge oversees each one. Some of the cases are heard by jury, and some are not. Appellate courts, or court of appeals, there are 13 courts of appeals, or circuit courts. Each court is overseen by a rotating panel of 3 judges who do not hold trials, but instead review these rulings, or the rulings of the lower trial courts. Court of appeals are made up by Congress, not the Constitution. So nowhere in Article 3 of the Constitution does it say the Court of Appeals has the power to do this, 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 and this. Court of Appeals formed out of the Marbury versus Madison judicial review and Congress's decision to create appellate courts. All right. Here are the 13 courts of appeals and U.S. district courts. So as you can see, there are 13 judicial circuits, 11 in the geographical area as marked on the map, and then there are 2 in Washington, D.C. So you see our district circuit, the Court of Appeals, here's cases from Alabama, Georgia, and Florida. And you can see the different colors represent the different circuits. Okay? The U.S. court system operates on principles of what's known as stare decisis, which is Latin for stand by things decided. This means that today's decisions are based largely on rulings from past, and tomorrow's rulings rely on what was decided today. Stare decisis is important in the U.S. common law system, in which the consistency of precedent ensures greater certainty and stability in law and constitutional interpretations. Former Supreme Court Justice Benjamin Cardozo summarized precedent by saying, "Adherence to precedent must then be the rule rather than the exception if litigants are to have faith in the even-handed administration of justice in the courts." When legal facts of one case are the same as legal facts of another case, stare decisis dictates that they should be decided in the same way. All right, now that we have kind of talked about our dual court system, we've talked about stare decisis and precedent, we're going to kind of talk about how someone goes about to select judges. All right, at the federal level, the president nominates a candidate for a judgeship. The president's nominee is then discussed with the Senate Judiciary Committee. After a committee vote, the candidate must be confirmed by the majority of the full Senate. Finally, he or she is sworn in by taking the oath of office. Highlight this portion. All judges and justices in the national court systems serve lifetime terms in office. So once a federal judge secures that judgeship and is sworn in, they are in for life until they decide to resign. So the highest court in the land is known as the U.S. Supreme Court. The U.S. Supreme Court, there are 9 judges, 1 Chief Justice, and 8 Associate Justices. As the national court of last resort for all other courts in the system, the Supreme Court plays a vital role in setting standards of interpretation that other courts have to follow. The Supreme Court's decisions are binding across the nation and establish the precedent. Remember, precedent, stare decisis, they're one and the same. So precedent is how previous cases with similar circumstances have been ruled on, should be that going forward consistently. It is wise to know that originally the court only had 6 justices, but in 1896 Congress changed the composition of the court to 9 justices. Again, they all serve lifetime appointments, and their annual session begins the first Monday in October and ends the following June. So they are currently in session right now. You've probably, if you've seen the news, you would see news of the different hearings. I think the biggest one right now was the student loan forgiveness hearing, if you're listening to this in the spring. So those cases that they're hearing now, they won't issue the final rulings until the end of their session in June. So whatever's being heard now, we have to wait until June to see the outcome of those cases. Here are a couple of the most recent justices. I do not have Justice Kavanaugh on here because he was not in your book. But you have, let me change my view. You have Justice Elena Kagan, you have Justice Neil Gorsuch, and you have Justice Amy Coney Barrett. And here is the appointment timeline for all of the current sitting Supreme Court justices. Notice that the Supreme Court, we call the judges justices, not judges. That is a vocabulary that you have to understand. It's more of a formal, since they are the highest court in the land. So we've had Clarence Thomas, who is our most senior justice. He was appointed in 1991. And notice that the Chief Justice was appointed in 2005. So something that always confused me when I was trying to learn about this is you would think that the most senior person on the court would be the Chief Justice once the Chief leaves. But that is not the case. The President is the one who decides who gets the Chief Justice position. So you can have the longest tenure in the court and still not be the Chief. All right? So our most recent one, according to your text, was Justice Amy Coney Barrett, but we have had one even more recently, and that is Justice Ketanji Brown Jackson, who is the first African American female on the court. And if you look at the court composition, you will notice red is typically used for Republican. I'm going to use it in talking about the court as conservative, and the blue is liberal in their rulings. And so, because Supreme Court justices are supposed to be apolitical, that is not, they are supposed to be outside of the influence of politics in their rulings. However, that's not always the case. But you do see that the current composition includes 6 conservative justices and now 3 liberal justices, because Justice Jackson took over Justice Breyer, who retired. So how does the court select cases? The Supreme Court accepts fewer than 2% of as many as tens of thousands of cases as it is asked to review each year. 4 of the 9 justices must vote to accept the case. This is called the Rule of 4. A petitioner asks the Supreme Court to grant what is known as a writ of certiorari, which is a request that the lower court send up its records on the case. The Solicitor General, who is the lawyer who represents the federal government, decides which cases should be appealed from lower courts and personally approves each one presented. The court takes into consideration external influences, not just from interest groups, but also from the public, from media, and from the Solicitor General. So you're typically highly likely to have a case accepted by the court if there's conflicting decisions among the lower courts of appeal, or if the decision by the lower courts conflicts with the precedent or the standard that has been set in lower rulings. And the questions that the U.S. Supreme Court is asking, remember, the federal court system looks at constitutional questions. All right. So let's talk a little bit about the Solicitor General. The Solicitor General is a lawyer who represents the federal government before the Supreme Court. Most of the cases the Solicitor General brings to the court will be given a place on the docket. which is typically about 2 out of 3. In cases in which the United States is not the petitioner, or what they call respondent, the Solicitor General may choose to intervene or comment as a third party on the issue. Remember, the Solicitor General has a lot of influence and can recommend that the justices decline to hear cases. It's been shown that while Solicitor General's special influence on the court is not unlimited, it does remain quite significant. Here are 2 Solicitor Generals. So the first one is Thurgood Marshall, who was later on the Supreme Court. He was the first African American to hold the solicitor position. And then you have Noel Francisco. He's the 47th Solicitor General of the United States. Thurgood Marshall is really, when I think of Solicitor Generals, he's the one that I think of, just because he's had some revolutionary writings and kind of opinions out there as a Supreme Court justice. All right, let's look at some procedures of the Supreme Court. Once a case has been placed on the docket, there's something called a brief. And a brief is basically a short argument explaining each party's view in the case. Those briefs have a timeline that has to be submitted to the court. They have a deadline that has your initial briefs in. Then once the initial briefs are put into the court, each side has an opportunity to review the opposite side's brief and respond to that. So after all the briefing is done, also the Solicitor General has an opportunity to send in briefs. Third parties that have a special interest in the case might send in briefs. But once the briefs are sent in and done by a deadline, the court will hear oral arguments from October to April. During oral arguments, each side has 30 minutes to make their case. And if you've ever seen an argument live, they have a clock, and that clock starts at 30 minutes, and each side starts to kind of make their case. I think we're going to talk about this a little bit later, so I'm going to mention it here. If not, then you get the information on this slide. But oral arguments are not just lawyers making a case before the court. The purpose of oral arguments is really for the justices to ask questions of each side. And it's not uncommon for an attorney to be making an argument, and midway a justice interrupt that attorney and ask a question that they have. So oral arguments is really about justices having an open forum with the attorneys. When the oral arguments conclude, justices go back into what is called a conference. And conferences is really where the decisions are made of the court. So conferences typically last about 2 weeks. The Chief Justice starts the conference. He or she sits at the head of the table, and they give their opinion about the case first. And then each justice speaks in turn. It's in descending order of seniority, ending with the most recently appointed justice. The judges then take an initial final vote in private before the official announcement of the decision is made. And then the Chief Justice assigns someone of the majority opinion. So the majority would be if they all vote. If 6 of the 9 justices voted one way, the Chief Justice would assign someone out of the majority, those 6 justices, to write the opinion of the court, which is the ruling. And then the most senior member of the minority opinion will decide who writes that minority opinion. Haha, did I set myself up great or what? So let's talk a little bit more in depth about the judicial opinions that I was just talking about. So remember, court opinion sets the precedent for future cases. Stare decisis, precedent. The Supreme Court's decisions are not always unanimous. However, the published majority opinion or explanation of the justice decision is the one in which the majority of the 9 justices agree. The dissenting opinion is written by any of the justices who disagree. If a justice agrees with the outcome of the case, but not the reasoning behind the outcome, that justice can write what's known as a concurring opinion. So there are times where the majority may rule a certain way and use a certain test, like the Miller test. And a judge who was in the majority opinion might say, I don't agree that the Miller test should be used here, but I do agree with the outcome. So I'm going to write a concurring opinion saying that I agree with the outcome, but I have a different reasoning for that. That would be a concurring opinion. A justice's decision is influenced by how he or she defines his role as a jurist, and with some justices believing strongly in judicial activism or the need to defend individual liberties and rights. Other justices believe in judicial restraints, which leads them to defer decisions to the elected branches of government. Justices' personal beliefs and political attitudes all influence their decision making. We're human. We are influenced no matter how apolitical we try to be. Sometimes it's hard. And the court themselves can be influenced by another court, the court of public opinion. We know that public opinion can sway legislatures, it can sway the executive branch, but it also can sway the justices. It's happened in the past. Hopefully it will happen some more in the future. So Supreme Court scholars have suggested that there are many factors, including those political philosophies, that the judges use in determining how they decide cases. One of the most fascinating topics is judicial ideology and interpretation. These judicial philosophies are widely studied by reading the justices' reasonings and opinions. First, there is strict construction. Advocates of strict construction often contend that the government should do nothing that is not specifically mentioned in the Constitution. This is sometimes known as textualism. Justice Scalia was a prime example of this and described textualism as an attempt to determine the meaning of the legislation. Textualists do not take into account the debates around the text or the problems the legislation was trying to address. They solely focus on what the text says. Next is a philosophy known as originalism. This is a conservative philosophy, along with textualism, in which the justices look at the intentions of the founders who wrote the legislation or the Constitution to determine the meaning of the phrasing. In order to help them discern the founders' intent, they may look at founding documents such as the Federalist Papers, which you guys have read, or notes from the Constitutional Convention. Next is a more liberal philosophy known as modernism. Modernists seek to examine the Constitution in the context of today's society and to consider how modern life affects the world, affects the words in the document. And finally, there is structuralism. Structuralism is another mode of constitutional interpretation which draws inferences from the design of the Constitution. It looks at the relationship among the three branches of federal government, the relationship between the federal and state governments, and the relationship between the government and the people. Executive and legislative branches check and balance the judiciary. The president does this through judicial nominations, the Solicitor General's involvement, or submission of what's called amicus briefs. So remember when we talked about those third-party briefs, those are known as amicus briefs. Congress retains power to modify the federal court structure and may accept or reject presidential nominations. They don't have to accept a nomination for a Supreme Court justice. They did it with Merrick Garland. Congress also may rewrite the law or begin a constitutional amendment process if the court rules on something they don't like. The most significant check on the Supreme Court is executive and legislative leverage over the implementation and enforcement of its rulings. This process is called judicial implementation. The court relies on the executive branch to implement or enforce its decisions, and on the legislative branch to fund those. All right, so that concludes our discussion on the courts. Here is a picture of our current United States Supreme Court. I know this lecture was long and had a lot of material. I hope you enjoyed it. I hope you learned something. And as always, feel free to reach out to me. Have a great day.